Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode, we are starting our part 1 of the Doctrine of Privity of Contract versus Consideration. The Doctrine of Privity of Contract versus Consideration. In my last class, I talked about the evolution of the Privity of Contract, and before that, I talked about the introduction to the Doctrine of Privity of Contract. But today's class, there is something that we saw in that last class in relation to what the judge in Tweedle versus Atkinson say. Who is the judge? Whiteman J. He said when a party is a stranger to the consideration, then that party cannot sue on that contract. The case before that was what? Price and Easton, where we're told about a stranger to the contract. And I told you that I would discuss more on this in this class. Do you understand that? I will discuss more on that in this class. And before we go into the crux of what we are to talk about today, if this is your first time of coming to my channel, then I want to say a very, very big welcome to you. Thank you so much for coming to my channel. Please don't forget to click the subscribe button as well as the notification bell. Don't forget also to share with your friends and colleagues and those people that you know that will be interested in watching this video. Lastly, please follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. And now we go straight into what we are talking about today. We are talking about the Doctrine of Privity versus Consideration. This is the first part. So let's go to our class. Now, the historical development of privity is very closely linked with the Doctrine of Consideration. The cases of Tweedle and Price clearly showed that there is a close relationship. Indeed, there is a school of thought that there is no difference between the Doctrine of Privity and the rule that consideration must move from the promisee, which formed the view of the majority in the two cases. However, the Doctrine of Privity is separate and distinct from the rule that consideration must move from the promisee. Now, I want us to understand a particular illustration, which I'm about to say now. X makes a promise to Y and Z to pay £100 to Z in exchange for a consideration made by Y. I think that this still goes with the Lassisi case that we are talking about. So, Mr. Macaroni is saying that I am going to give you 100,000 naira. And for that 100,000 naira, I want you to give your land at Banana Island to who? To Taoma. Right? Who is furnishing the consideration? The person furnishing the consideration is Macaroni and Lassisi. Why Taoma is not furnishing any consideration, right? So in such a case, Z is privy to the contract. Who is Z? Taoma. Taoma is privy to the contract but cannot maintain an action against Lassisi, who is X, having not provided consideration for who? For X's promise. That is Lassisi's promise to what? To give the land across to Taoma. The person that provided consideration is who? Is Mr. Macaroni. And since it is Mr. Macaroni, it means that it's only Mr. Macaroni that can enforce the transaction. Abi? No problem. Now let's continue. Privity and consideration constitute two hurdles for Z, who is Z, Taoma, to surmount and not one. Why? Because not only must you be privy to the contract, Z is privy, but still Z still needs to furnish consideration, and that's Taoma. It is arguable that the above example seem to put the cart before the horse. Since consideration is an essential ingredient of a contract, no contract exists between X and Z in the absence of consideration by Z. Therefore, the purported tripartite contract is actually a bilateral one between X and Y. It is therefore submitted with respect that the party to a contract will essentially and necessarily be privy to it. Even those who maintain that the rules are separate and distinct nevertheless concede that the relationship between them is so strong that it is difficult to reform one without the other. Now, this is what I'm saying here for you to have a perfect understanding. This is basically what I'm telling you. I am telling you that when you are talking about privity and consideration. Now, I need you to understand that I am not thinking from the aspect of, what is the present law. I am thinking from the aspect of what should the law be. There's a difference between what the law is and what the law ought to be. Do you understand? For example, when you are talking about murder and the law against murder, nobody should be allowed to kill another person now. Agreed, right? So what is the law? Nobody is allowed to kill another person. What ought to be the law? Nobody should be allowed to kill another person. Therefore, in relation to murder, what is the law and what ought to be the law? They are the same. We cannot say that in relation to every other aspect of law. What is the law and what ought to be the law are usually different. So here I am speaking in relation to what ought to be the law. Now, when you are talking about what ought to be the law in this context, we are saying that for you to even talk about privity in itself, you must at the first time agree that there is a contract. Are you listening to me? Now, what am I talking about? For you to have a valid contract, there must be offer, acceptance, and consideration. Correct? Offer, acceptance, consideration, right? In the case of Lasisi and Mr. Macaroni, who has made the offer, acceptance, and consideration? Lasisi and Mr. Macaroni, correct? So you would agree with me that there is a binding contract, right? So the question here, are you listening to me? The question here should not be a matter of whether or not Tahoma has furnished consideration. There has been consideration furnished. Tahoma need not furnish another consideration to make that contract binding. That contract is a binding contract. What we should be asking, are you listening to me? What we should be asking should be, is Tahoma privy? I want you to get what I'm saying. Okay, let me give you another example for you to understand this privy thing I'm talking about. Now, we have Tayo and Shubomi. Tayo and Shubomi. Tayo and Shubomi are friends and they stay in school hostel. And Shubomi's phone spoiled. So Shubomi said, what will I do like this? And I need my phone to be able to communicate and all that. So Shubomi now wanted to buy a new phone. And that new phone is what? The new phone is iPhone 30 Pro. Now, when he went to Computer Village, he dropped 500,000 naira and got iPhone 13. Now, when he now came back, the person that he got it from is Gen Z shop. The name of the shop is Gen Z. Now, when he got back to the hostel, he was so happy. I've brought my iPhone 13 Pro. Anybody, their daddy. And he entered the hostel. And then his friend, Tayo, now saw the phone and said, let me check out your phone. As he was checking out the phone, Tayo realized that there were a lot of defects on that phone. And Tayo said, Shubomi, phone Oshilolo Rao, you want to go and buy stupid phone. This phone is going to spoil in less than 1 week. It's fake and all that. Then Tayo now went to court. Now listen to me. Tayo now went to court. Tayo went to court to sue Gen Z, the company. Are you listening to me? So the case was Tayo versus Gen Z. Now when the lawyer for Gen Z entered, the lawyer for Gen Z looked at Tayo and said, are you the one that came to buy something in the shop? No. So what are you now doing here? He was now forming, my lord, Shubomi is my friend. So, and the question is, there are two questions to ask here. First of all, are you privy to the contract? Now, I want you to look at another perspective that we are coming from. When you are asking a person, are you privy to a contract? You are trying to ask that person, were you mentioned in the contract? Are you listening to me? If you are mentioned in the contract, you might not be a party to the contract, but you are a third party. That third party gives you privity. Are you listening? But the rule of privity is that not only must you have been mentioned, you should have furnished consideration. Listen to me. Not only must you have been mentioned in the contract, in the one against Lasisi and Macaroni, Tahoma was mentioned. Tahoma is privy. Tahoma is a third party, but Tahoma did not furnish consideration. Let's go back to Easton and Price. Who was mentioned? Dele was mentioned. Dele is the person that was being owed £3, right? Or 3K, right? Dele was mentioned, right? In Twiddle and Atkinson, the husband was mentioned. Not only was he even mentioned, it was written down that he should have the ability to sue. But still, what the court in each of these cases told us is that not only must you have been mentioned, That is for you to be privy. Being mentioned in a contract makes you privy to the contract. You might not be a party to the contract because the parties is between the two contracting parties, but you are privy to the contract. But you being privy to the contract without giving consideration, you cannot sue on that contract. That is the rule. Are you listening to me? That is the rule. You must be privy and you must have furnished consideration. So there are two rules that must be followed before a person can be said to have privity of contract, right? Now, what I am now saying as what the law ought to be is that you should not be mandated to furnish consideration in a contract where consideration had already been furnished. Mr. Macaroni had already furnished consideration by giving 100,000 naira. Mr. Macaroni has already furnished consideration. Now let us go back to Dele and Sheyi. Sheyi has already furnished consideration to Akin that I will work for you, but in exchange you will pay my 3k to Dele, right? So if there has already been consideration furnished and there is a binding contract, why does Dele now have to furnish another consideration, making it two consideration? Why? That's the question. When Mr. Macaroni has already furnished consideration to Lasisi for that land of 100,000 naira, why exactly again does Taoma have to furnish another consideration? The question is Taoma privy? Was she mentioned? Whether or not as a third party, the question is, was she mentioned? So far she was mentioned that she is privy, she should be able to sue. Is in the case of Tayo that went to court for a friend, Shubomi, it was not mentioned in the contract. Was it mentioned that anything that has to do with phone when Shubomi went to buy the phone from Gen Z? No, now. Tayo is just basically a busybody. Person where they no send. Shall you get? They did not send Tayo to do anything. He is forming, oh, I am the law. You entered and say you want to sue based on privity of contract that neither were you mentioned or you furnished consideration. You didn't do any of them and you are in court. But Taoma might not have furnished consideration, but she was mentioned as a benefiting party. Do you understand? So when you are talking about this rule of privity of contract and consideration, it is my submission that a person who is privy need not be a party, but a person who is privy need not furnish consideration to be able to sue to get the benefit of a contract. Are you listening to me? So I hope exactly that you understand what I'm saying. Let us read the latter part. The third party is in most of the cases a gratuitous beneficiary. Now listen to that. Taoma is a gratuitous beneficiary. Why? Because Taoma did not furnish consideration. So we would be saying that's the argument against privity, that a gratuitous beneficiary should not be able to sue to get the benefit of a contract that he did not furnish consideration for. So a third party is in most cases a gratuitous beneficiary. He or she has given nothing in return for the promise. On what basis should a gratuitous third party, Taoma, gratuitous third party, be allowed to maintain an action? The answer to that question is that in the third party's case, the consideration has been provided by the other party, Mr. Macaroni, and all that is happening is that the third party, that's Taoma, in effect being allowed to take advantage of the consideration provided by the contracting party, Mr. Macaroni, which was the intention of the fathers in Twidu's case, as you can see. Now, so this case is distinguishable from a gratuitous promise where no one has provided consideration for the promise in respect of which the claim is brought. So I want you to understand the terms of what we are talking about. Now, I'm trying to make you understand that when we are talking about a gratuitous beneficiary, Taoma could be said to be a gratuitous beneficiary, but she is privy to a contract where consideration has already been furnished. So the question, let me ask the judges that used to form I know the law. My lord, I want to ask you a question. If Taoma has to furnish consideration, the same consideration that Mr. Macaroni has already furnished, my lord, don't you think that Lasisi is going to get two consideration for the price of just one thing that he's doing? My lord, don't you understand? Mr. Macaroni has given Lasisi 100,000, to which Lasisi agreed. He agreed to the 100,000. That based on that 100,000 that Mr. Macaroni has given to him, that he was going to give the land to Taoma. So, my lord, are you trying to say that it should be the law that where somebody has agreed, because it's not the person that is suing, but the beneficiary that is suing, that beneficiary should not have the right to collect what he is rightly owned? Do you understand? Because in this case, Lasisi is forming I no know am, but you have collected 100,000 naira from Macaroni and you have not given the land which you ought to give. You have not given it to Tauma. Isn't that going to be injustice, my lord? Look at yourself, look up. Isn't that injustice? So now Tauma is now saying that, oh yeah, come and give me my land, and you are saying that she should have furnished consideration. How many consideration do you want there to be furnished in the contract? Mr. Macaroni has already furnished consideration. Is that not consideration enough for Tauma to be able to collect? Do you understand? So far Tauma is privy to a contract where somebody has furnished consideration on behalf of that thing that is going to Tauma. That thing that is going to Tauma, the person has furnished consideration for it. Then Tauma, whether or not she is a contracting party, whether or not she made offer, whether or not she made acceptance, whether or not she furnished consideration, should be able to collect it. That is my submission. Do you understand? That is what the law ought to be, in accordance with my own perspective. That's what the law ought to be. But what is the law? The law is, as a third party, you must have been mentioned in the contract, but not just that, you must also have furnished consideration. That is the law. But my submission is, so far consideration has been furnished by somebody, in this case Mr. Macaroni. So far consideration has been furnished, Tauma should be able to collect that land, because the essence of Mr. Macaroni furnishing that consideration is so that Lasisi will give Tauma the land. So how come Mr. Macaroni will now furnish the consideration of 100,000 naira to Lasisi and die? Because what everybody will be saying is, oh, why can't Mr. Macaroni come himself? Mr. Macaroni don't die. Oh yeah, he don't die. Oh yeah, who is now supposed to come? Is it not the same Tauma? So if Mr. Macaroni has furnished consideration for something and there is a binding contract, wouldn't it be injustice? You self, my lord, Yeram, wouldn't it be injustice that you now say Tauma should not be able to come and collect because Tauma did not furnish consideration? But there is already consideration for a binding contract, my lord. Do you understand? So, like I said, this case is different from a gratuitous beneficiary where there is no consideration furnished at all. Mr. Macaroni has not furnished consideration, but Lasisi promised that he was going to give Tauma a land. So in that case, if Mr. Macaroni has not given the money, then Tauma cannot say I want to collect the land. But that's distinguishable from when Mr. Macaroni has actually given the money. Do you understand that? So I guess that you are clear on what my position is. But I need to emphasize it over and over again. This is my submission. This is what I think. That is not the law. The law is that not only must you be privy to a contract by being mentioned as a party, not necessarily as a contracting party, because the contracting party is Lasisi and Macaroni. So you must have been mentioned as a party. Do you understand? To a contract. So if you have been mentioned as a party, you must have furnished consideration for you to be able to sue. That is the law. But what I'm saying, which ought to be the law, so far consideration has been furnished by a contracting party, a third party who is a beneficiary should be able to sue in the event that that contracting party cannot. Do you understand that? And that is where we end our class for today. Thank you so much for watching to the end of the class. I hope that you enjoyed the lecture. Please make sure that you share this video with your friends and colleagues and people you know that are going to be benefiting from this video. I will see you in my next class where I talk about the part 2 of this particular lecture. Now in my part 2, what will I be talking about exactly? I'll be talking about 3 cases in my next class. We'll be talking about Dunlop Pneumatic Tire Co Limited versus Selfridge Limited. We would also be talking about the case of Scrutons Limited versus Mainland Silicon, and we'll be talking about the case of Beswick and Beswick. Now in each of these cases, one thing that we are going to look at is how the court had used privity of contract and consideration. Are you privy to the contract? Were you mentioned in the contract? That's number one. And number two, did you furnish consideration? Now we'll see, is there any court that actually said that, oh, since you are privy, that is, you have been mentioned, since you have been mentioned in the contract, you need not furnish consideration, since the contracting party has already furnished consideration? Did any court say that? Or are all the courts of the opinion that so far you are privy, you must also furnish consideration for you to be able to sue? So let us talk about that in my next class, where I'll be talking about the part 2 of this lecture. I will see you in my next class.